how do you allocate assets between a married couple? And the answer is carefully. And one of my mentors that used to tell clients, he would say, for every complicated situation, there is a simple answer, and it's wrong. Complicated situations often call for complicated answers. And that's why you guys all kid me about the charts, and you want to know if your chart's longer than the other person's chart, and all chart envy and all that stuff. But this is a fairly typical situation. Spouse 1 has a revocable trust. Spouse 2 has a revocable trust. That's to avoid what we call probate and guardianship, which I'll cover this afternoon. That does nothing for creditor protection. In fact, it can hurt creditor protection. So that rule is don't even put anything in your revocable trust unless you're sure as to what the effect will be on your estate plan. We draft estate plans where all the complex language is in the revocable trust, and then the will just says everything I have goes in the trust. But that doesn't mean that you should put assets in the trust. In Florida, if you put life insurance in the trust or annuities in the trust, you may have lost your protection on that. But in Florida, we have something magical called tenancy by the entireties. It comes from the English common law, 1776. Which was adopted by the state of Florida in the 1800s. They adopted the common law of England as of 1776. They missed 100 and some odd years, but it still worked out. And under tenancy by the entireties, a married couple's assets cannot be touched by a creditor unless the creditor has a judgment against both spouses. Both spouses. So that's why Marcia and I have a limited partnership. It's called Poodles 3 Limited Partnership, and those of you who know us know why it's called Poodles 3. We don't always have the same 3 poodles, but we always have at least 3 of them. And in that partnership, we own that partnership as tenants by the entireties. So, and then that partnership is owned in part by the gifting trust on the second from the left, which is for our children. Whether we like them or not, we need to have them in our partnership. But we have it done because we need multiple members. But we have it done in a way that the trustee of that trust can spend the money on our children or one or the other. It's flexible, so if one of them turns out to be a stinker, they won't get anything from this trust, even though the trust is irrevocable. So you want flexibility. You want flexibility because you may love your children now, but you haven't met who they're going to marry or what's going to happen after that. So you want flexibility. On the right-hand side, I have a lifetime bypass trust. So I have a $5,490,000 estate tax exemption, and I could put $5 million, which is what David paid me in legal fees last year for all the work I did for him. I could put that $5 million into a trust for Marcia and the children, and that trust was formed by me, but it's not for me. It's for Marcia and the children, but they didn't put anything into it. It's completely creditor-proof to the IRS, to the Department of Justice, and to every Florida and every creditor in the world, and it will never be subject to estate tax. So when it doubles in value twice to $20 million in the next 20 years, that's going to be free of estate tax. And from income tax standpoint, I can pay the tax on its income, which reduces my estate further. So when the Trump administration and the Republicans fail to pass their estate tax repeal law, I'm going to be really busy with pent-up demand. Or if they pass the repeal law, you're all going to get my CV, because I'll be looking for a job in your company. A lot of clients have us prepare an agreement which says if one of us dies, the survivor has to put most of the assets into a trust. The trust is commonly in Nevada, which is a creditor protection state, and it's to be held for the surviving spouse and descendants and not for the next spouse and the spouse after that and the spouse after that. Not for the in-laws, it's just for the spouse and children. So if Marcia were to pass away because she does that ladder thing again and it doesn't work out again, then if we have that agreement, then I have to set up the Nevada trust under that agreement, And therefore, that transfer to the Nevada Trust is not a fraudulent transfer. I didn't do it to avoid a creditor. I did it because it was in the agreement. So that's just something we like to do.